On behalf of COSAL, the Committee to Support the Antitrust Laws, I want to welcome you to a panel discussion on the House Antitrust Subcommittee's historic tech CEO hearing. I am Pamela Gilbert. I'm with Cuneo, Gilbert, and LaDuca. I'm the Executive Director of COSAL. COSAL was founded 35 years ago to promote and support strong private enforcement of the antitrust laws. And we thank you for tuning in to what promises to be a very lively and interesting conversation with prominent experts. And with that, I'm going to turn this over to our panel and to our moderator, who's Mark Suter. Mark is with Berger Montague, and he is with the COSAL Young Lawyers Division. And I just want to give a big shout out to Mark, because this is just one of many programs that Mark has come up with that is helping COSAL keep antitrust at the top of the nation's agenda and in the news during, particularly during the pandemic. So he's really been doing a great job with that. With that, I'm going to thank you for pulling it together and just turn it over to you, Mark.
Thanks so much, Pam. Yesterday, the House Judiciary Antitrust Subcommittee held its sixth hearing on online platforms and market power, titled Examining the Dominance of Amazon, Facebook, Google, and Apple. During Amazon CEO Jeff Bezos, Facebook CEO Mark Zuckerberg, Apple CEO Tim Cook, and Google CEO Sundar Pichai answered questions over the course of 5.5 hours of live testimony. All four companies are currently under some form of federal investigation. Apple by the DOJ, Amazon by the FTC, Facebook and Google are also both being looked at by regulators. With Google in particular, there are expectations that we might see a lawsuit filed by the DOJ in the near future related to digital advertising. There are also international investigations underway. Apple and Amazon are both currently under investigation in the EU, and the EU has hit Google with more than $9 billion in fines. All of this is to say that yesterday's hearing and the related congressional investigation are not the only or even the biggest threat that these companies face. Nevertheless, it was a momentous opportunity for Congress to ask some of the most pressing questions about the role that technology and these digital platforms in particular play in our society for consumers, other businesses, and on the world stage. We're fortunate enough to have four amazing panelists and subject matter experts with us today to offer their insight and expertise, three of whom actually submitted formal comments to the House Subcommittee. Our first panelist is Hal Singer. Hal Singer is a managing director at Econ One, a senior fellow at the George Washington Institute of Public Policy, and an adjunct professor at the Georgetown University, McDonough School of Business. He has research published and testified on competition-related issues in a wide variety of industries and has extensive experience providing expert economic and policy advice to regulatory agencies as well as before congressional committees. Diana Moss is the president of the American Antitrust Institute. An economist by training, Dr. Moss's work spans both antitrust and regulation. She has spoken widely on various topics involving competition policy and enforcement, testified before Congress, and appeared before state and federal regulatory commissions. Sally Hubbard is Director of Enforcement Strategy at Open Markets Institute. Sally has testified before the US Senate on self-preferencing by big tech, the House of Representatives on Facebook's and Google's roles in the weakening of journalism, and the Federal Trade Commission on acquisition of nascent competitors. She previously served as an Assistant Attorney General in the Antitrust Bureau of New York State. And our final panelist is Michael Cades. Michael Cades is the Director for Markets and Competition Policy at the Washington Center for Equitable Growth. Prior to joining Equitable Growth, Michael worked as an antitrust counsel for Senator Amy Klobuchar, and before that spent 20 years investigating and litigating antitrust actions as an attorney at the Federal Trade Commission. Well, thank you all for joining us today. Michael, I thought we'd start with you. As former antitrust counsel for Senator Klobuchar, the ranking member on the Senate Judiciary Subcommittee on Antitrust, Competition Policy, and Consumer Rights, you've been around one or two of these subcommittee hearings in your days. How, if at all, in your opinion, did yesterday's hearings differ from past congressional hearings on similar issues that you've been a part of?
Thank you, Mark, and thank you, COSAL, for having me on the panel, and also for all the great work you guys do. A really important organization at a really important time. So I think the hearing yesterday really just showed what happens when congressional committees and their staff get access to documents. I mean, the concerns about about digital market and text have been raised for years by concerns being raised, by the members of the panel, by individuals who have felt harmed, by reporters. But until yesterday, there was sort of a ship's passing in the night quality to the debate. Right, so someone would sort of raise a concern, and the public response of the companies would be, "You don't. That's not what's going on. We're not trying to squelch competitors. We're not. You know, we love our. If we're Amazon, you know, their responses. We want third-party sellers to succeed. If Facebook, we're all about connecting the world." And so you would just sort of have, you know, if you had this kind of hearing without the documents, that's what you would have heard. You're doing this, no, we're not. Yesterday, what was really a problem for, I think, for all the CEOs is that the committee members were prepped, they had done their homework, they had looked at the documents, and they were ready when they got sort of a platitude response. Emails went up on the screen, documents went up on the screen, and it was really the first time, at least that I thought, that the companies really had to address that these concerns being raised from the outside have support in the company's own internal documents. And I think that really changes the whole debate, because now it's less about what these companies are doing, because there's confirmation that they're doing lots of the things that the concerns were raised about, and what does that mean, and what should we do about it?
Thanks. As I mentioned, each of our 4 panelists have previously testified before Congress and other regulatory agencies. Opening to the rest of the panel, did anything about yesterday's hearing strike you as unique or unusual?
This is Sally. I'm happy to jump in. Yeah, I thought it was incredibly unique hearing. In fact, I can't remember a hearing like that in my lifetime, at least my adult lifetime. I know there were the Microsoft hearings. I was still a bit on the younger side when that happened. You know, just as Michael said, this was a look under the hood, right? And we've had all these platitudes. For years, the tech giants just give these platitudes like, we respect our users' privacy. We have lots of competitors. We care about free expression. That's generally how they've always responded to any criticism, is just these general platitudes. And it's been, there's been great reporting done. There's been other investigative work done, but then to have their own documents and have that look under the hood was just so powerful. And I think so important for the public to see Congress taking on these powerful companies in such an aggressive and forceful way. I think that was one of the most important things about this hearing, that to me, it's historic. I cannot recall a time where I saw members of Congress as prepared as I saw them yesterday, and as willing to take on corporate power in such an aggressive, forceful way. And I think it's really important for restoring the public's faith in institutions and for building momentum for the enforcement that we hope is going to come soon.
Mark, this is Diana. I'll chime in just briefly on what Michael said, which I think is an important point, about how Congress is a very public-facing organization, has put together the hearing, and in a very methodical way. Unlike other hearings, given the intensity with which the committee has pursued this topic, I think what really jumped out at me is that obviously Congress has done an amazing amount of homework. They have a boatload of documents, many of which are potentially very damaging. But I think they made the case for what I would call a handoff to the antitrust enforcers. There's obviously only so far Congress can go, and what they have done on the investigatory front is very different than what an antitrust enforcement agency would do in terms of alleging a violation and then having an evidentiary type of proceeding. So I think what Congress did is do an amazing amount of footwork, very valuable footwork, and really the handoff, I think, is imminent.
If I could just weigh in on I think the big takeaway, I mean, there are several, but if I could just kind of boil it down, maybe I'll pick up on something that Sally said. This kind of was the culmination of the anti-monopoly movement. And you could feel it. It was palpable, like something was changing. We were witnessing potentially history. I feel like we saw what would happen now with just unchecked monopoly power, the threat that it poses to both democracy and to even to capitalism. But also, I thought that the way that the tech CEOs came off was jarring. It was almost and I mean this in a kind of a fun, loving way, but it's almost a mobster mentality. Just kind of thuggery was on display. We heard things like, if you didn't submit to Google stealing your idea, you were going to be disappeared from search. If you didn't buy fulfillment from Amazon at potentially super competitive prices, you're going to be disappeared from the buy box. If you didn't buy ads from Amazon, you'd be flooded with counterfeits. I mean, this is the kind of stuff that you don't typically associate with kind of mainstream business practices. It's kind of outside of the norm. And I think everybody on the panel knows of these strategies, but when you saw it in the light of day, it was jarring. And I feel like something might actually shake loose out of this.
The antitrust establishment loves to declare that big is not bad, but even under the existing law, the means by which monopoly is acquired and maintained matter. The hearing yesterday showed that the methods that Amazon, Apple, Facebook, and Google use to obtain their dominance are anything but innocent. Along those lines, which CEO fared worse in yesterday's questioning? From whom do you think the most blood was drawn, and what was the most damaging admission made? Michael, would you like to go first?
Didn't I go first last time?
Sally, would you like to go first?
I'm not sure that one stood out. I felt like more than what the CEOs said themselves, it was the questions that were more revealing, right? The questions that exposed the hot docs, that showed the details of, Instagram. I've been saying for years that Facebook acquired Instagram to eliminate a competitive threat, but then to see the internal emails where they're talking about the strategy of it was, I thought, incredibly damning. Google's acquiring a competitive threat as well was put on display. I felt like the good stuff was in the questions more than the answers, to be honest. I can't think of anything that I thought, oh, he just admitted to something that was really important. I thought it was more the evidence that was put forth in the public eye that was more important.
I thought there were a few important admissions, if I can go. To answer your question, Mark, I think Zuckerberg was the worst, and he was followed closely by Bezos. But Bezos admitted that access to the buy box was influenced by your purchasing fulfillment from Amazon, which is basically admitting to a tie-in. But Zuckerberg made the biggest mistake, in my opinion, and it was a bit of an unforced error. He was being asked about denying access to Facebook's API to Pinterest, but not denying it to I believe it was Netflix. And he just gave away the answer. He said, yeah, we perceive Pinterest to be a social network competitor, which, immediately, reveals that this is a discriminatory refusal to deal. It's the exact sort of stuff that is squarely within the ambit of antitrust. And you would just hope that if a CEO is being prepped to testify, that they wouldn't just step right into it. And I feel like this was like stepping into it, with a few inches going up the shoe.
But how can they really deny that? There's already been public documents published showing that they do that. I mean, that was the 643 documents that the UK Parliament published, showed internal emails of Zuckerberg saying, "Yeah, go ahead, add them to the list and cut them off." I mean, so
I know, but he had to give the explanation, exactly that way. It just seems like it was just serving it up. It was too easy, And my surmise is that he probably doesn't know what a discriminatory refusal to deal is, and so he's like, "Yeah, we did it because we consider those guys to be potential horizontal rival." So anyway. This is the kind of stuff that gets the antitrust nerds excited.
I guess I would sort of echo what Sally was saying, that I actually think which is true, right? I mean, this is a group that sort of will get this. A good cross-examination often has little to do with what the answers are. It's what the questions are, and that's really what I thought was most effective in that hearing. You can tell. I'm gonna tweak Hal just a wee bit here. I mean, I'll give Zuckerberg credit for being honest about it and not, I mean, maybe they sort of realized that they had to be a little careful on sort of stretching the truth. But like, look, if that's what Facebook's doing, that's what they're doing. And, I'm not going to blame him for being honest. Blame him for other things, but not being honest. the one the one mistake, I don't think this was a big deal, but like I am just, and I tweeted about this, I am just shocked that at any point that Facebook thought going to the regulatory approval of Instagram was going to dissuade anybody from who has concerns about that transaction. Look, I was at the FTC, did not work on the matter, but I was there when it happened. I'm not defending the agency at all, but also, you know, like I think I said this, like bringing up the FTC approval of Instagram is basically like your buddy's in the water and there's a shark coming and you just kind of throw a bucket of blood around him or her. Yeah, and which is exactly what happened. But so that was like the moment for me where I was really like, dude, you really need to get refunded the whatever fee you were paying your prep lawyers who came up with that idea.
This is Diana. I think these are all really good points, and you can look at specific examples of the best and the worst performances or the most damaging. But if you go up to the 10,000-foot level and kind of frame this around the fact that these 4 CEOs as very public-facing figures were responding to very pointed questions about the conduct of their companies, people are going to walk away with impressions. So more generally. Cook, I think, did the very best job of dodging questions about the commission structure for the App Store. And, one would think that, well, this is not even a problem at all. 80% of apps are free, and we have a 30% commission structure on the first year, 15% on the second year, and everybody does this. Well, that was a very general response. Very persuasive response, but his performance was the best, I think, because the question wasn't posed to him in a way that would have actually unearthed exactly what Apple is doing and how it exercises its market power in the App Store. On the other hand, what we heard from the Google CEO, I think, was the most detached from the gravity of the concerns that Congress has about the conduct of these companies. You often heard him talk about in terms of acquiring smaller rivals, that these small startups and smaller potential nascent rivals are both our rivals and they are complementary to us. So, he's trying for sort of a bifurcated strategy of saying, yes, well, we admit that we compete with them or they potentially compete with us, but as we add them to our ecosystem, they complement the rest of our set of interconnected markets. That is a feed directly into potentially a Section 7, consummated Section 7 challenges. This is exactly what antitrust enforcers are going to be focused on in doing that. And I don't think that particularly supported their case.
Can I chime in on a Cook moment? Because I agree with Diana that Cook kind of won the day, but that's kind of like saying that someone won the NFC East, right? I mean, he did okay. There was one time where he kind of stepped in it. I just want to bring this out. It kind of struck me as funny, is that he was accused of taking down an independent app that had was for parental control over what your kids can observe on the internet. But he took it down at the same time that he put up his own affiliated app, I think called Screen Time. And when asked why he did it, he came up with this privacy pretext. He said, oh, we did it because we were concerned about the privacy aspects of these competitive alternatives. We wanted to put a better one. But the Congresswoman pointed out that when he eventually got around to bringing back the independents that he took down, they had no change. Those independents had no changes to their privacy settings or controls. And so it kind of exposed the pretext that Cook was offering for what he probably was doing, which was just self-preferencing, trying to give preference to his own app. So anyway, he did a good job, but it's more like the NFC East, as I would say. Sorry,
to add on to what Hal says, I think that's something that's really important for enforcers to be looking out for, is this use of privacy as a pretext for monopolization. We've seen that in a lot of different examples, cutting off, Facebook cutting companies off their API and justifying it by privacy. There was even internal communications published back with the 643 UK Parliament documents showing that Facebook was like, yeah, let's cut off our competitor. We'll say it's for privacy reasons. So this being used as a pretext is something that enforcers really need to look out for. But I just remembered one other thing that I thought came off really badly that Bezos said. It was right after a document showing that Amazon referred to the marketplace sellers as their internal competitors. That was the phrase, internal competitors. And he was like, well, we always do our best by the marketplace sellers because they're so important to our business. And it's just like it was just exposed that you refer to them as your internal competitors, and then we're supposed to simultaneously believe that you're always operating in their best interest. So I thought that was another kind of completely unbelievable moment in the testimony.
And if I could chime in, I think the story Hal relayed about Apple really sort of is an example of where I started. I mean, in a typical hearing, the representative wouldn't have had the time. Oftentimes, the senator's representative just wouldn't have the time or the background to push back. So you would have gotten the question, answer, and probably moved on. And what this really showed is not just at the chairman level, down the line, and I would say down the line, even on the Republican side, Representative Anderson, Representative Buck even, but even the guys who were asking things that I didn't think were relevant, people really took on the entire committee, took this hearing seriously and knew what they wanted to ask about. And that is, it's rare, and I don't mean it as a criticism, it's just that this was really a prepared committee yesterday.
This is Diana. I want to second what Michael just said, but I also want to kind of put it into contrast with what we actually heard collectively from the CEOs. I mean, this is a sector in the economy. These are specific industry, specific companies that, that are really under the microscope. And I think what we did not hear was any willingness to come to the table to even talk about the competitive problems that we see in the sector. Instead, the strategy was to deflect and to fall back on the virtues of the platforms, which, I mean, you have to admit is a pretty bold strategy in light of how much public attention and concern over their competitive conduct is. So just to really run the list, this is what we heard from the CEOs. We have small market shares and we're not dominant in any markets. We are consumer focused, can be trusted, and consumers love us. We have helped small companies, especially during the time of the pandemic. Competition is good and we see lots of it. Our products have wrought economic miracles. And finally, we do lots of R&D and we invest in the economy and we support lots of jobs. I mean, that all sounds very good, but it's a very blunt type of response given where the committee is, the amount of work the committee did, and the level of competitive concern over these companies. I found a big disconnect in that approach.
Thank you all. That was great. The committee's questioning covered a lot of ground, including, unsurprisingly, some of which was not even tangentially related to competition, looking at Jim Jordan. But what, in your opinion, was the most important question that was not asked? What topics weren't covered that you wish should have been? Hal, why don't you go first?
Yeah, so I suggested this on Twitter and Zephyr came after me with a passion, but let me see if I can defend what I did. I would have liked to have heard a question about remedies, and not so much that the committee needs permission from the tech firms to write any new laws, but instead to find out what the CEOs think in terms of what these new laws would inflict on them, what kind of harms would be inflicted, if any. On the tech company. So, for example, in a prior hearing, Google CEO was asked if he could abide by a non-discrimination regime, which of course is my baby, and he said, yeah, of course I could live by a non-discrimination regime. And the reason why this is important, guys, is that whenever these rules or these ideas start to come down, a ban on misappropriation of data or a ban on self-preferencing, right? The tech CEOs are gonna haul out their army of consultants and economists, or what I like to refer to affectionately as the Amazombies, And they are going to say that the sky is going to fall, that, if you don't allow us to self-preference, if you don't allow us to appropriate data from third parties, right, the whole business model is going to be in tatters. We're going to stop investing. So we know it's coming. And I feel like if you had CEO admissions at the hearing that said otherwise, it could be used to rebuff these future assaults.
I just want to chime in on what Hal has said and maybe push back a little bit. In taking 10 pages of copious notes yesterday over a 5-hour period, I went back through my notes and I found that the most mentioned type of remedy was to regulate. We actually heard Zuckerberg say, the whole privacy problem really should not be within the domain of private companies to solve. He was actually endorsing some sort of more general public policy framework for doing that. Now that's just on the privacy side, which I believe to be a social regulation problem, and it's a tiny bit of an antitrust problem. So we're looking for the right tools to fix these issues. But you heard many of the members on the committee talk about regulation. And the word popped up 6 or 7 times. So I do think the issue of remedy is in the background very much. And I think that's the direction that this is going in.
I would just say,
Sorry, go ahead, Sally.
Okay, sorry. I'm hesitant about getting the input of the CEOs on the remedies because we've already seen some efforts to do this with, like, Zuckerberg, for instance, came out with his own set of remedies. One of them was data portability. Data portability isn't going to work unless you get rid of the network effects problem. So you really need interoperability, not just data portability. I can take my data from Facebook and Instagram, but where exactly am I going to port it to, right? So my point is, I find that the CEOs tend to offer remedies that won't work because really any remedy that's going to work is going to affect their profitability. So, I think kind of the time for them to, I think the time for any kind of self-regulation has passed. I think it's time for law enforcers and legislators to do their job of enforcing the laws and protecting the American people. And I'm just really hesitant to, take their input or trust any self-regulation.
Sally, I actually want to throw this next question at you.
Okay.
Much of the public conversation surrounding big tech platforms often focuses on breaking them up. Which segments of these companies, in your opinion, are the most likely candidates for restructuring, and how might that look?
Yeah, so it's different by company, right? With Facebook, I think there's a strong case to unwind the WhatsApp and Instagram acquisitions. There's already been a case brought by the EU where they said that Facebook lied to them when they were seeking approval for the WhatsApp acquisition, saying they couldn't combine the data. So, there's actual deception in that deal. I can't imagine they told the FTC something different than they told the EU. I think we have strong evidence that these deals were illegal acquisitions of competitive threats, and that we also really need to inject competition into the market to deal with a whole slew of harms that Facebook is causing. With Google, I think breaking up the ad tech ecosystem so that it's not like controlling the buy side and the sell side, and then also doing a same thing for Google and Amazon that Lena Khan has argued for in her paper, Separations of Platform and Commerce. And Elizabeth Warren has argued for this as well, which is separating the platform layer from the commerce layer. So if you are controlling the platform, you're not also competing on the platform. So if you are controlling search, you're not also dominating vertical search. If you're controlling the Amazon marketplace, you're not also selling products on the marketplace. So separating out the platform layer from the commerce layer. And then also with some huge companies like, Amazon, I don't understand why we need to have the biggest e-commerce marketplace also be the biggest cloud provider. So I think it would make sense to separate AWS from the retail. There's been lots of evidence of Amazon using its profits from AWS to cross-subsidize some of its anti-competitive practices in the marketplace, like predatory pricing. So I think you need the most important thing to me is that separating the platform from the commerce layer, but I think you could also have some horizontal, some breaking up of the different components of these massive companies.
So, Dari, if I weigh in here, so I want to agree on a part and just offer kind of, well, an alternative way to think on another. But certainly, I'm with Sally when it comes to whenever one of these platforms, I'm thinking of Facebook, like the mashup with WhatsApp, and Instagram. That to me is the most natural area for a structural separation. You're basically undoing something that was kind of put together unnaturally to begin with. But then we have these harder ones, like I'm just going to pick on one, like Amazon's fulfillment service. You could make the argument that, and we know now that we already knew, but it's confirmed that access to the buy box is conditioned on the merchants buying the fulfillment from Amazon as well. And so, you could solve that problem. You could solve all these problems, right? With the structural remedy that says that Amazon needs to spin off its fulfillment. I'm just making that up. But if you can address these problems through just traditional antitrust, I guess you'd call them conduct remedies, which is you can't tie, you cannot engage in that tie-in. People can buy fulfillment from you, but you can't tell them you're going to deny them access to the buy box unless they buy it. That would be an alternative and, in my opinion, less invasive remedy to solving the problem. And I would kind of lay out the same solution with respect to the whether or not Amazon should have a foot in the merchandise space. Well, it doesn't really bother me that they're trying to get a toehold in soap products, for example, or bubble gum, whatever the hell they're selling. The problem is using the platform to preference their own and stealing these ideas through the misappropriation. So if it turns out that we could stop this harm through a conduct remedy, say a ban on self-preferencing or ban on misappropriation, it's conceivable that we could still allow Amazon to have a toehold in these verticals. They just couldn't use their platform to leverage the power to monopolize those vertical markets.
So Hal, I gotta disagree with you. Conduct remedies we know to be incredibly ineffective in terms of restoring the market to a competitive level. We've got lots of evidence in vertical mergers on the failure of conduct remedies. They do nothing to de-link the incentive to exercise market power. They require monitoring and enforcement, and depending on who is implementing the remedy, Congress through laws versus the antitrust enforcers through consent decrees. It's not a good use of the court's time, and it really treats the agencies and the courts like regulators. So I don't think imposing conduct remedies on companies with this level of power and complexity is necessarily an option. But by the same token, I would note that the whole breakup discussion is very romantic, and but when you get down to brass tacks, there are a lot of really troubling, difficult questions that would have to be worked through. There are the break up remedies, which would require legislative involvement, I believe. And then there are the break off remedies, which would be undoing consummated mergers like Facebook, Instagram, and the like. None of the discussion I've heard, at large really talks about, well, who's going to buy these assets? Say you have an independently controlled network or platform, who buys the affiliated businesses? These are probably concentrated markets. Well, you don't want the assets landing in the hands of an already powerful market player. And then, of course, there's the big question of how you regulate those existing or remaining untethered platforms. We have lots of examples in public utility regulation. British Rail, for example, which was spun off, and then we had lots of safety and operational and reliability problems. There are questions about incentives to innovate on a standalone asset like that. So these are all really, really big, sticky questions that would go into a discussion about the bigger break, which is break ups versus the break offs through Section 7 enforcement.
Can I just follow up with you, Diana, because
Sure.
I'm confused. You say that the conduct wouldn't work, but then you say that structural is romantic. So just tell me flat out, what's your position? Should Amazon be able to have private label products or not? Because I see you have one of two choices. You either tell them they can't use the platform to preference their own, or they can't have a foothold in brands. But you can't say, I don't like either one of those, so it's a tough question, and let's just throw our hands up in the air.
Well, I'm not saying that. There are other options. There are options to and I'm not saying this is the preferred option, I'm speaking as an economist, that if they were left vertically integrated intact, there are ways to ensure fair, non-discriminatory open access to a platform, whether it's ads, whether it's vendors, retail vendors, whether it's anything. There are ways to do that through open access regulation, through interoperability standards, possibly through some forms of data portability, although I think there are a lot of questions there as well. There are ways to ensure that those types of behaviors are not available to the companies that are
Those sound
selling
like
or
all
operating
conduct
on their
remedies.
Hal,
platform.
Those sound like
can I jump
conduct
in?
remedies to me, which you seem to poo-poo earlier. But,
No,
but
this-
okay, let's
no,
go on. Let's go
No,
on.
but this would be part of a bigger regulatory regime that a Congress would have to set up with a new piece of legislation. And we would
Yes.
have to have a digital markets regulator.
Yes,
Okay.
good. All right. Okay, maybe we are in the same place. Okay, go ahead. Let's go ahead.
So, yeah, I mean, what I hear Diana saying, and she'll be, I'm sure she'll correct me if I'm wrong, but remedy is actually really complicated, and I think it's a mistake to sort of say we know now what a remedy looks like. Any of these problems will not involve a simple remedy. There are costs and difficulties along them all, and take a look back. Think about when people point to the ultimate divestiture remedy. It's the AT&T remedy when it was broken up in a monopolization case. But it's not like they walked into court one day and said, okay, we're going to spin these all off, all the baby bells off. But that certainly intuitive made a lot of sense there, right? But like the rest, for the next 10, 15 years until the passage of the Telecommunications Act, Judge Green spent almost all of his time enforcing all the related provisions to make the divestiture work, right? So like, this is not an either, it's like unlikely to be an either or. And what makes things work is going to be dependent on both what we think the violations are, what we think the company, where we think that there's legitimate conduct that we want to protect, what we think the incentives are, right? So, I'm glad you guys all were specific, because when Mark asked that question, I'm like, yeah, this is an important question, but I have no conclusions here, except to say that like we are just a long, long way from understanding how to fix the problems, because we've been spending the last 5 years trying to convince the world that, actually there are real problems here. And so like, hopefully yesterday we made a good step there. Now we go to whether those problems, courts will recognize them or Congress will act to solve them. And then and then finally someday we'll get to a point where Hal and Diana can have their dispute, and it'll be, hopefully they'll have enough evidential basis that they can come to an agreement.
I'd just like to add one thing. Are you done, Michael? Sorry, I'm gonna cut you off.
No, sure. And you too, like the three of you guys, I won't be part of that conversation. I'm just sort of, we're not ready to resolve the issue yet.
Just to add, I think plus one to the point Michael made about it's not an either or situation. One thing that drives me completely insane is a common rebuttal I get whenever I say we need stronger antitrust enforcement is, oh no, this isn't an antitrust problem. This is a privacy problem. Oh no, we don't need antitrust enforcement. We need neutrality laws. And my question is yes. My response is yes, we need all of those. This is a both and situation, not an either or situation. We need to break out the entire anti-monopoly toolkit, which is privacy laws, antitrust enforcement, both structural breakups and ongoing enforcement of Section 2 to make sure we don't have that exclusionary conduct. We need interoperability regulations, neutrality regulations, transparency rules, anti-corruption. I mean, there's a whole slew of solutions we need to address these problems. And it's not an either or situation, as Michael said. The other thing is, I understand it's complicated, but saying it's complicated is also often code for do nothing. So while we have to admit that it's complicated, we also need to not give into that inertia that it's often used as the excuse to not do anything. It's all too complicated for anyone to touch is a very successful and common argument made for why we can't actually take action. So I'm not saying anyone here is saying that. I'm just saying that that's something that I want to put a red flag on that, because that's a common refrain that you hear from the pro-monopoly crowd.
Yeah,
So, and just to be,
I just want to respond really quickly to what the comment that Sally's making, which is an important one. You know, the whole anti-monopoly debate, if you want to call it that, or call it, you know, the pro-competition debate, you know, as it has gained momentum over the last many years, the focus, especially in big tech, has been on the use of antitrust to fix all problems. And AAI has pushed back on that pretty hard, because we believe that antitrust should be vigorously enforced. We've been doing that for almost 25 years at this point. But we want antitrust to be used as it was designed to be used, and in accordance with the intent of the law. So antitrust should go after the problems that it can fix. Antitrust can't fix every problem big tech. And unfortunately, this whole debate got started with a lot of rhetoric about how antitrust should fix all problems big tech. And I think that's, you know, that has not done a service to the whole, you know, to the whole effort to make the big tech companies accountable under the antitrust laws. Antitrust should address competition problems. We need social regulation to address the systemic widespread privacy issues. We need intellectual property law to chime in. We need lots of different pieces and policy tools to make this happen. And it is only now, years later, that I think the realization has occurred that this is a public policy problem. This isn't just antitrust enforcement. It's not just social regulation. It's a lot of problems put together in a monumental public policy issue, and it requires a public policy solution.
But Diana, I do think, real quick, I do think you underestimate the amount of problems and the type of problems that adequate competition enforcement would solve. I'm saying we need to use all the toolkits, but we also need to enforce the antitrust laws. And to think that that won't impact privacy and all the other concerns, I think, is looking too narrowly at all the
that's not
gamut
Sally,
of effects.
that's not what I'm doing, Sally.
Okay.
I've been a major proponent of
and where have we been? I mean, we've gotten nowhere.
Yeah, so whether it's price and non-price effects, which includes quality, which thus includes privacy, which includes innovation. You know, we have been at the forefront of advocating for the most flexible, fulsome enforcement of the consumer welfare standard, which has not been enforced in that way for the last 40 years. So you don't have to convince me about any of that stuff. Like, we've been advocating for that for years, and antitrust plays a very important role, but it should not be tasked for doing things that it's not intended to do.
Yeah, and I'll just weigh in if I could. You know, I think that when we break this thing down into the very specific and concrete acts that we find offensive, it's not all that complicated. You know, yesterday we heard a lot of stuff about how the tech platforms are misappropriating data from third parties who are dependent on the platform, right? And we don't have to make up a regulatory template from scratch here. Michael cites to telecom, which of course I love and I cut my teeth on. In Judge Green and the breakup of AT&T, but I would also point you to a regulatory template that Harold Feld points to, which is 1974-ish. Congress passed rules that stopped AT&T from misappropriating data from third-party vendors in the early days of the computer inquiries, and this had to do things with like home monitoring or alarm enforcement. They just said you cannot steal data in this way and use it to rip off and then invade the vertical that you're going up against. And so you know, that's something that I think that if we don't like it, and there's a question as to whether or not antitrust can go after this conduct, misappropriation of a third-party data, then we can use a tool outside of antitrust to go after it as well. That's not to say that we can't also use antitrust. There are tons of things that we can use antitrust for here, but if we just focus on little bites, little pieces of what we find offensive, we can go after it. And I would say the same thing with respect to discrimination, self-preferencing. 1992, Congress passed the Cable Act, Section 616, prevents vertically integrated platforms from giving preference to their own networks. How is it adjudicated? It's through a complaint-driven process in front of an ALJ. You know, none of this stuff has to be that original. We have regulatory templates, and it's got to be, as Sally says, it's going to be a combination of antitrust enforcement and non-antitrust enforcement, but all part of a larger anti-monopoly toolkit.
So I would just say, I just want to be clear, since in no way was I suggesting the fact that this is difficult is a reason why it shouldn't be done, nor am I suggesting we need absolute certainty, which is kind of the twin sibling of it's difficult. I'm just sort of saying, like, there are templates, we need to look at those, but we also need, I just sort of feel like that debate has not been fully joined, and we're not, I'm just not willing to say, yes, Hal's proposal for the discriminator regulator at the FTC is the perfect solution. Not to say, I'm not willing to say it isn't either. I just think, like, this is the next step in the public policy debate that we need to have. And we will have to make a decision, and we don't have to be certain.
So I want to focus this next question on antitrust law in particular. So we heard, as Diana mentioned, Tim Cook claim that Apple does not have a dominant share in any market or category that they do business in. For his part, Jeff Bezos focused on Amazon's share of the global retail market and resisted the proposition that e-commerce could be considered a separate market unto itself. If I understood him correctly, Mark Zuckerberg seems to think that Facebook competes in the market of, quote, giving people a voice and an opportunity to express themselves. What issues do an overly formalistic emphasis on market definition and or market share pose for enforcement against unilateral dominant firm behavior, especially in the context of these amorphous tech giants? Diana, you want to give that one a shot?
Sure, that's a great question, Mark, and I think people walking away from listening to the 5.5 hours of hearing were really struck by a lack of focus on market share and dominance. And I think it's important to realize that when this finally gets to the antitrust agencies, and we have an agency or agencies with the will to actually bring a Section 2 case, but also bring in parallel Section 7 cases on consummated deals, that, the lift is going to be heavy. This is what Congress cannot do, and it harks back to what my original comment was, which is Congress has gone about as far as it can in its investigatory process. We now need antitrust enforcers to they need to be past the torch and get to work. And monopolization cases are difficult. It's got to show a monopoly, and you have to show that there was the deliberate leveraging or maintenance of that monopoly. And market share and market dominance are step one in that very difficult process. And we've had very few monopolization cases in this country over the last many years. You can count them on two hands. And so that's a direct feed into how important that question is. And all we heard was, we are small, we have lots of competition, we're not dominant in any market. Amazon has a 4% market share in retail in the United States, and on and on and on. And I was disappointed not to hear more pointed follow-up questioning by the members on the committee to really get to the heart of how to appropriately frame their market shares. So that I believe to be a real weakness in the takeaway from the hearings. But again, that will be up to the antitrust enforcers to be able to make the case for a dominant position, and how that dominant position was abused or used to maintain monopoly power through the whole laundry list of exclusionary conduct that we heard about yesterday. So, I think we're at a crossroads here where enforcers need to pick up the ball.
If I could jump in, I certainly share Diana. I mean, as an antitrust lawyer, I guess I can still call myself that, or antitrust policy person. I certainly, it was incredibly frustrating to hear the company's definition of the market. But I think in the context of the hearing, I think the committee members were right not to talk about that. Because, right, the audience here yesterday is not me or Diane or the antitrust bar. I think it was really about the public. And I don't know how much of the public, if you're not an antitrust person, I think sort of the focus on the actual conduct that's troublesome, the bookseller who was cut off, the documents on, that Facebook saying, oh, we don't really have to worry about startups because we can just buy them if they're a threat. I mean, like, I think in that field where we were yesterday, that was exactly the right place to focus, because this was about educating the populace, the American public, about what's going on. If that was a deposition, yeah, totally different, right? Totally different. You would want to go after that. So, like, I think Diana's point is right, that at least on the investigatory side, not necessarily legislative policymaking side, Congress, I think, they've really done an admirable job about pushing what the issues are, and it is now up to, one result of this investigation is it makes it clear that the agencies need to take that and they need to do their job, which is deal with the market definition issue. So that was just sort of my response.
Sally, are you about to go? Sally, are you about to go?
Yeah, I was just going to say, I agree with Michael about the hearing. I think that, direct evidence of monopoly power is the power to exclude, monopoly power is defined as a power to exclude competitors or control prices. And there's just direct evidence of the tech giants doing this in spades. And I feel like the emphasis on the market share is a distraction, because that's really indirect evidence of monopoly power, right? I know that a lot of courts still require that. I think that's unfortunate when you have such ample evidence of direct evidence of monopoly power. But I do think it's a distraction. I like to call Amazon's 4% stat the irrelevant market share. That's my antitrust nerd joke.
It was.
Good.
Go
ahead.
Better than most of the antitrust jokes.
So yeah, what that's all about is this fight, Sally teed up, between direct and indirect evidence of market power. And if you have direct evidence, it speaks directly to a firm's ability to either raise prices over competitive levels, or in Amazon's perspective, suppress prices below competitive levels in their exercise of monopoly power. That's the end of the game. And we don't need to get into these formalistic definitions of what's the right share, and all this. That's the domain of the antitrust defendant, and of course that's where they want to play. But something came out this week, this study by ISLR, that estimated what's happened with Amazon's fees on merchants over the last 5 years, and they've gone up from 19% to 30%. And I look at that and I say, my God, that is direct evidence, right, of the ability to push down the compensation of your sellers on your platform, and to do so in a profitable way. Did any of these merchants defect in mass in such a way as to defeat that price cut? And the answer is no, right? Presumably it was profitable, and if it was profitable, then we know that Amazon has buying power. We don't need to go out and define some silly market and go measure Amazon's share of it to get at the truth.
Yeah, but Hal, do you really think that, given that given the lack of any Section 2 cases in this country over the last many years, that a court, and given what we've seen in the courts recently with opinions coming down in AT&T, Time Warner, Sprint, T-Mobile, Sabre, Farelogix, do you really think a court is going to make the leap to accept direct evidence without any supplemental or buttressing circumstantial evidence about market shares and market concentration? Do you think any court is going to do that in a Section 2 case in this day?
Diana, you can definitely get to those market shares after you've done an investigation, right? Like as Michael says, after you've done the investigation, you've done reviewed all the documents, you've done all your depositions, then you've really pinpointed the harms, you'll be able to create or to define the relevant product market, right? But from the outside, it's really hard to do that. And so we end up getting these BS market definitions, right? And so as long as we're not the ones who are in the weeds, being able to look at, do the investigation and come up with a definition, I think it makes sense to focus on the direct evidence. There are court decisions where courts have accepted just direct evidence. I don't have them off the top of my head, but I know it has happened.
In Section 2 cases? Has it happened in a Section 2 case?
Yeah.
There's one case.
One case.
Realty versus Remax in the Second Circuit.
There you go. Yeah.
The other thing, all right, Michael, the other thing I would like to say is, like, the thing that frustrates me so much about the plaintiff side and enforcer side of antitrust is that we do not do what the defense side does. The defense side gets a decision that they hate and they narrow it and they say it doesn't apply to anything. They get a decision they like and they expand it and they say it means everything. You know, Trinco basically means there can never be a Section 2 case again. And on the enforcement side, we get a bad decision like Amex and we're like, oh, we can never win again. Or we, you know, say, oh, well, this has only happened once, so we're not even going to try. Like, we need to be just as aggressive as the defense side is and say, this is a way, this is direct evidence, and make the argument. I'm not saying you can 100% win, but I think too many times we don't even go for it, or we accept the defense side's interpretation of cases and don't try to make the case law evolve in the right direction. I mean, case law is intended to evolve, right? And instead, we just let it solidify and congeal and let it antitrust be useless because we just accept these decisions instead of going for it.
Oh, there are a lot of advocacy groups that don't accept those decisions. You know, AAI being one of them. I also don't think that direct evidence is not a go-to form of evidence in a potential Section 2 cases. Of course, there's direct evidence. Of course, it will be used to make a case. But I guess I'm expressing skepticism more generally in the Section 2 area about whether that will carry the day without being supplemented by other forms of evidence. I would also make the point that what we heard yesterday from the hearing in terms of stories, very compelling stories from smaller rivals who were excluded from various platforms, that tells a very compelling story to the public. But you know, an enforcer is the first thing an enforcer is going to say is, okay, well, that's one competitor, and we need harm to competition. It's not harm to competitors. And so, you know, that's why I'm so anxious to see the handoff to the enforcement agencies to do the work that needs to be done to make successful cases, to bring successful cases here. But it's, you know, the harm to competition versus harm to competitors was definitely something that an observer of yesterday's hearing might take away.
So if I could I want to chime in on the direct evidence thing, since I spent almost all of my time at the FTC with this issue. And I guess, you know, I sort of feel like maybe there appears to be a little more disagreement here than there really is. I mean, what I hear Hal saying is that direct evidence, if you have it, is the best evidence. I think that's that's basically true. A little asterisk on what, not everything that looks like direct evidence is necessarily direct evidence. But at the same time, I think one shouldn't be sort of so copacetic that the best economic direct evidence is actually going to be effective in court. And I think the place to look at this is the best direct evidence I've ever seen in antitrust cases are in pharma cases, right? Like generic entry happens, brands lose 90% of their sales because for a cheaper price, 6 months. How is that not direct evidence? And the FTC has been litigating, and private plaintiffs have been litigating these cases for decades. And they, in every one of these cases, continue to make the direct evidence point. They all also make a market definition point, and they do exactly what Sally says. Right? This is something I learned from George Carey and Bill Baer when I was a baby attorney. Like, their view of market definition was you put on your best effects evidence, and then you say it defines the market. But you never say you're doing direct effects, because then you avoid the legal issue, right? So, right, you look at what was done in the recent cases, right? This is what they do. So, like, I think we all agree direct evidence matters. I think I would say we probably all also agree that in any litigation, you got to define. You're gonna, in the Section 2 case, you would be foolish not to offer the court a market definition and market shares. You're gonna have to do both. And I think Diane is right. And again, I don't think there's a dispute here. I sort of felt like there was more anger.
Agreed. But will you guys mind if I put the direct evidence as my Roman 1A and the indirect stuff as 1B? Can we agree to that at least?
I think that's a litigation decision, Hal.
Well, that's how
really
we do
is.
It. That's how we roll. Next question.
Which is fine. I don't know that there's an answer to that, but I can see somebody else saying, no, we're going to start with having, going out with all the stupid stuff or the less relevant, I shouldn't say stupid, the rest of the relevant stuff, because we got a judge who is really hung up on market definition. Like, I don't know. I mean, like, that's just a litigator decision.
No, I know, but Michael, if we have evidence that Amazon was able to raise their tax from 19 to 30%, right? That's a massive takeaway from the merchants, right? That's suppressing or pushing down what the merchants get to keep of their own wares, right? And was that price suppression profitable, right? We can go answer that question, right? To me, that's some heavy duty stuff if you're in a court.
So I would say, one, still not as heavy duty as generic entry. Two, right? I mean, Amazon's response, you heard it, is they're going to say, wait a minute, we are providing, the fees went up because we're providing more services, and the plaintiffs are going to say, yeah, but nobody, but you're forcing people, and right? So it's not that I necessarily agree or disagree with the power of that evidence. I'm saying, like, it is it's just, we know how, we've seen enough antitrust cases and what plaintiffs face, that, like, it's not an either or, and it's going to be a litigation strategy based on what they think about the judge and the jury about how much they're going to rely on indirect evidence versus direct evidence. And when we're not in court, yeah, I think we all agree, direct evidence is what we should be looking at. And if we lived in a reasonable judicial world, the courts would say that too, but they haven't.
Okay.
But that's not a reason not to use it. You should still be using it.
We agree again.
I agree
So much
with
agreement
everything
on this panel. It's like it's sleepy. Go on, Mark. What's the next question?
David Cicilline told reporters that the long-awaited report on the findings of the subcommittee's investigation will be published as early as late August. The report will be the culmination of the more than year-long probe into the tech company's power and will include findings from the committee's multiple hearings. Any predictions on what we can expect to see in the report? And what do you think is going to happen next? Sally, you want to jump in?
Well, I hope they included the recommendations that we sent them in our letter from Open Markets, which is like the whole toolkit that I mentioned previously, not just antitrust enforcement in the form of structural separation, but also robustly enforcing Section 2 against specific instances of exclusionary conduct and unwinding illegal mergers, and being very, very scrutinizing of any further mergers, no matter what the size, to determine if they're acquisitions of competitive threats. And then, of course, like I said, privacy, interoperability, non-discrimination. The acronym I use is PAIN. Privacy, antitrust, interoperability, non-discrimination, or neutrality. Because if you don't put the tech giants in pain and you just make them pay a little fine, you don't actually fix the problems. If you want to be nicer, you could add T for transparency and make the acronym PAINT.
Can we add M for something that would stop the misappropriation, Sally?
I also want anti-corruption in there, so I don't know. CM
Oh no,
PAINT.
now we just
There
have a
you go.
big word salad.
That's the general gist of the recommendations that we included in our letter. So I hope they come out with some strong policy suggestions and then follow it up with legislation. And I hope it gives momentum to the ongoing enforcement investigations by the DOJ and FTC and state AGs to ensure that they get that they actually sue and go to court and don't accept some sort of a weak settlement, which is one of the things that I'm concerned about.
Anyone else have any predictions? What's happening next? Where's this all going to lead?
Michael?
So I sort of taking a step back, what would a bad hearing have been from an enforcer's standpoint? I think it would have been a hearing where it was just very convoluted, and the takeaway was kind of like, some people asked some hard questions, but this all seems very complicated. So I think the most important thing is this hearing, and the reason why that would be a bad hearing is it would have relieved pressure on the agency, right? It would have, it would have fed into the narrative like, we need to be careful. We need to be worried, and we need to be too careful. I mean, obviously you should always be careful, but delay is what we need to make sure we're certain about everything. So I think most important, that didn't happen. If anything, rather than release pressure on the accelerator, I think the hearing yesterday put the accelerator closer to the floor. So I think that's really important, that there's a lot of there's increased pressure on the agencies to act, to be effective in their investigation and to be diligent, but to be quick. So I think that's really important. I think then the second thing, sort of picking up on what Sally's talking about, the second question is, what should Congress do proactively? And one can have the view that yes, there are antitrust violations, but there needs to be either changes to the antitrust laws, because the laws actually make things too difficult, or and there can also have the position, and we need these other tools employed, whether it be regulation, sort of competition regulations like the type Hal talked about, or how we deal with privacy in a way that promotes competition like Sally's talking about. And I think after tomorrow, all those are on the table. I would expect the report to talk about all of those. And if the report comes out in August or even September, like I think we're close to the election, but it will be teed up to, as Chairman Sicilian said, is that this very well could be a critical issue, and that the legislative regulatory side could be a top issue come January of 2021.
And it's hard to predict exactly what's going to happen, but I think yesterday's hearing was sufficiently successful so as to raise the likelihood that not only is concrete legislation going to be proposed, but it might even pick up some bipartisan support. And that's to me the most heartening thing. When you look, there was support among even the Republican members to pursue the tech platforms in a way that frankly surprised me a bit. So I'm hopeful, and we'll see what happens.
Well, thank you all so much for all of your incredible insight and expertise. We've been going for just about an hour. So with that, I want to pass the mic over to the president of COSAL, Rob Kitchenoff.
Thanks, Mark. As Mark said, I'm Rob Kitchenoff. I'm the managing partner of Weinstein, Kitchenoff, and Asher in Philadelphia, and I'm the current president of COSAL. I want to thank our panelists for a thought-provoking and spirited discussion, Dr. Hal Singer, Sally Hubbard, Dr. Diana Moss, and Michael Cades. We've enjoyed immensely your presentations today and your takes on yesterday's hearing, and your thoughts for where this enforcement will go in the future. Also want to thank Mark Suter for generating this program and for all of the wonderful work that he does both on behalf of COSAL and as the co-chair of the Young Lawyers Division. Thanks to Pam Gilbert, COSAL's executive director, for all of her fabulous work she does on behalf of all antitrust attorneys. The next COSAL event will take place in mid-September, and we're going to have another virtual program, a look at the Supreme Court, the composition of the court, and what that means for antitrust and class action enforcement going forward. The event's going to be sponsored by RG2. And with that, I thank you and close the program. Be well.